January 2016 meeting of the Tennessee Board for Licensing Contractors. We'll start with a roll call to my left.
Ernest Owens, Memphis, Tennessee.
Whittington, Johnson City.
Bill Mason, Greenbrier.
Mark Broad, Knoxville.
Jerry Hayes, Paris, Tennessee.
Cindy DeBus, Knoxville.
Reese Smith, Frank.
Order of business would be to adopt the agenda.
So moved.
Those in favor?
Aye.
Opposed? I believe the ayes have that.
Oh, I'm sorry, on the agenda, can we add a new order? We have somebody here from Go Build that can give us an update, so I want to go ahead and add that to the agenda.
Where do we want to put that?
We can do that right before the rules, if you want.
Okay.
Make a motion, we add the item to the agenda.
Second?
Second.
Those in favor?
Aye.
Opposed? Believe the ayes have it. Okay. Next, hardships approved by the executive director. Need a motion to ratify those.
So moved.
Second.
Those in favor?
Aye.
Opposed? Ayes have that. Next, we need to adopt Robert's Rules of Order.
Second.
Those in favor?
Aye.
Opposed? Ayes have it.
What we need to do is make sure everybody signs it and gives it back to me before you leave today, but you don't have to adopt it. It's just something that we need to do every year.
Okay.
Do we have it?
Everybody be sure and sign your conflict of interest and get it back to Carolyn today. Okay, next we have board meeting transcript. Had a chance to review those. We need a motion to approve.
So moved.
Second.
Second.
Those in favor?
Aye.
Aye.
Opposed? Ayes have it.
July, we don't have November yet, or is
Oh,
that?
the front page says July 2015.
Yeah.
Oh, yes.
Okay. License approvals. Waived, interviewed, revisions, LLEs and LLPs. We'll start with the waived.
I'll move for approval.
Second.
Second.
Those in favor?
Aye.
Believe the ayes have that. The interviewed.
I've got one, if we start this way and work that way, I guess. Do you have any interviews? Mine was for a home improvement. It's home improvement license number 5036. It was a reinstatement. They continue to work under the expiry term of the license, and my recommendation is for a $250 civil penalty for continue to work while expired. And that's in the form of a motion.
Second.
Those in favor?
Aye.
Opposed? Ayes have it. Revisions?
Well, I have three interviews. On number 69596, Quality Plumbing. Had a drug conviction in 2001. He's been clean since then. Got off probation early and has good recommendations, so I'll recommend that he be approved. on home improvement 8197 Southern Grace Handyman. He was in the Navy and was convicted of taking home airplane parts that belonged to the Navy in 2010. He's off probation. Otherwise has a good record and recommendation. His wife is still in active duty. I'll recommend that he be approved. HI 8234 Contemporary Home Designs had a drug conviction in 1998. He's been off probation for 8 years. Works for Tennessee State University doing on-campus construction and maintenance. And he needs to get his certificate of insurance with the proper certificate holder. But other than that, once that's done, I recommend he also be approved. So I move that all three of those be approved.
I'll second.
Those in favor?
Aye.
Opposed? Ayes have it.
I had one felony, Michael Smith, Nokian, off probation for 14 years.
Aye.
Aye.
Favor?
Aye.
Opposed? You got another one?
Talked to somebody in Alabama, bought the house for this, a young man's, he agreed to do it, he wouldn't like, not like. For here.
Favor?
Aye.
Opposed? The ayes have it.
On the interview, I decided to give a $350,000 license limit. I believe that's what I put on that, wasn't it? They had applied for a $1 million limit with no experience but personal experience and things involving projects. I believe the most expensive was $23,000. Except for a current home, that's a personal home that's under construction, and their estimate was in the $750,000 or $100,000 range. And rather than just deny the license outright, I thought a little compromise might be good at $350,000.
That's still a pretty substantial home.
It is.
Why don't you, if you don't mind, you might want to make a
Guys have that file down here? No, that's all right. I think Sycamore Ridge Construction.
Yeah, 69478.
You got it? Okay. And I'll make the motion that the board approve a $350,000 license limit and grant the license.
In favor? Aye. Opposed? Believe the ayes have that one.
I had One Source Power and Maverick Construction are both applying for a license. They have common ownership. One performs work on a union basis, one performs work on an open shop basis. Qualifier for both companies. And that's why we also had a complaint filed that they had bid a project in Tennessee. When I asked them about that, they said they had talked to them about the project and provided some budgeting information, but they have no firm bid or no contract. Recommending approval of those two licenses.
Policy, yes.
Second.
Those in favor?
Aye.
Opposed? Ayes have it. Visions? Got two files want to hold till the resolution of some complaints they have. So we'll probably. Favor?
Aye.
Opposed? Ayes have it. LLEs?
I put the following in form of a motion, 30.
Make a motion, we approve.
I put that in form of a motion.
Okay, second.
Those in favor?
Aye.
Opposed? Ayes have it. LLP? Or none? That's easy. Case?
David. Everyone, my name is David Taylor. I'm a construction lawyer with Bradley A. Rant Bull Cummings. I'm here on behalf of Brassfield and Gorey. As most of the board knows, one of the nation's largest general contractors, licensee in this state for more than 27 years. The request this morning is that the board withdraw the complaint that was initiated against Brassford last October. The history of this is that Brassfield went through its renewal process last summer. When they did that and everything was approved, they self-reported 2 lawsuits that had been filed against it in the state of Florida, filed by 2 homeowners associations. Those lawsuits are fully defended by Brassfield's insurance counsel. Brassfield has denied all liability. Some of you may know that Florida has a little quirk in the law where even though a contractor after construction of a condominium project even settles out with the owner, if a homeowners association takes over, they have the ability to sue the contractor years and years later after the condominium has been completed, and that's what these 2 lawsuits are about. So those were self-reported in April of 2015. In October of this past year, the board voted to initiate a complaint against Brassfield and presented it with a consent order. And of course, the consent order did not require Brassfield to admit any type of liability. The issue, and why brought him here today, is that Brassfield takes these sort of complaints, very seriously. The 2 lawsuits are in Florida, not Tennessee. There's been no allegation of violation of the board's rules or regulations. And the primary issue is that even though the consent order, underneath the consent order, Brassfield doesn't admit any liability, a complaint is a complaint is a complaint. And so Brassfield would then have to report the fact that a complaint has been initiated against it through any state that it does licensing through. Brassfield does a tremendous amount of federal work. That would have to be reported. When they provide bids for projects all over the country, there's normally a question in that bid that asks whether or not there are any type of proceedings brought against it or pending by any state licensing board. It also has the potential to potentially impact insurance rates, or have to report. So in a letter to Mr. Kilgore, copy to Ms. Lazenby in December, what we had proposed is kind of a win-win, which is if the board would simply withdraw the complaint with the ability to refile it if necessary, and then what we would do is periodically, as often as the board wants or as Mr. Kilgore wants, to report to the board on the status of those two Florida lawsuits. And again, I just want to be clear, this is not a complaint initiated by a third party. Apparently, because of the reporting, that's something that the board reported on, and so Brassfield very respectfully requests that the board withdraw the complaint under the condition that we regularly update the board through Mr. Kilgore as to the status of those two Florida lawsuits.
Was the complaint presented as a commercial or a residential complaint?
It was presented as a commercial complaint, and a litigation monitoring consent order was authorized.
Another one of those that was initiated by the staff based on the renewal application. We've had some discussion about that, and I didn't see any on our report. I don't know if they were on residential this year or not, this month or not, because we talked very much about staff initiating complaints based on voluntary submissions by our contractors. There hadn't really been any violation of our rules. And, you know, I know we instructed you last time to have a conversation was that conversation held?
Yes, this was done prior to you instructing me to have that conversation.
I understand that, but it's the same thing we talked about before, that we had too many, and we were dismissing them because they really weren't justified, because our rules hadn't been violated, and we were penalizing people for telling the truth on their renewal applications. So this sounds like another case of that. I'm sorry, and I'll take some responsibility for that being on the commercial subcommittee, not spotting that before. But I think he's got a very justified request here, and I hope that that's been resolved on these others, that they're not going to initiate complaints on their own when they're just because somebody disclosed, unless there's actually been a rule violated. So, do we feel like that's been resolved with council?
Right, Delta has been instructed whenever she gets a complaint like that to just check with Josh first before we open it, you know, to see if it's something valid that the board needs to take a look at. So
We have two categories, I understand. Now, we've clarified that as well. To close, which means it may still remain, or to dismiss, which is basically expunged from the record. Is that what we're doing? I move that in this case, the complaint be dismissed.
Second.
Those in favor?
Aye.
Opposed? I believe the ayes have it.
Thank you very much.
Thank you. Legal report, Josh.
Thank you. I'm just going to read the ones that the board has authorized changes to. Number 5 on the residential report, the board decision was to authorize formal and send a consent order with a civil penalty in the amount of $500 for unlicensed landscaping activity. And number 16 on the residential report, the board has authorized formal while sending a consent order with a civil penalty in the amount of $1,000 for unlicensed activity. Number 21, I need to get some more information on this one and their complaint history, and I'll try to do that before we adjourn today, because they had a history of 10 closed complaints, and this would be 11, so we wanted to see what the history was on those other complaints before making a final decision, I think. The commercial complaints, number 1, the board is authorized formal while sending a consent order with a civil penalty in the amount of $5,000 for turning in at least 5 renewals while failing to disclose respondents' conviction for distributing 500 grams of methamphetamine and use of a firearm related to drug trafficking. He didn't report that when he was convicted in 2004. He did not report that until his most recent renewal. Number 2 on the commercial, the board has authorized a letter of warning regarding the licensing limits and requirements for a landscaper's license. Number 4, the board has authorized a formal while sending a consent order in the amount of $1,500 for wrongfully pulling a permit and for unlicensed activity as to respondent 1 in that matter, and has accepted council's recommendation as to respondent 2 by authorizing formal and sending a consent order in the amount of $1,000 for awarding a job to an unlicensed contractor. I believe that concludes my legal report. Thank you.
Make a motion, we approve.
Those in favor?
Aye.
Opposed? The ayes have that.
We've got some draft of the Go Bill rules. If any of you got a chance to look at it. Let's see. A copy of the law too to go with the rules. Take one and pass it down. Whether or not y'all see any language you want changed or added. If you have any questions, we do have people from Go Build here that can address that.
I've got some questions as we get ready to.
Okay. We have Bob Pitts that can go ahead and. Sure.
Are you gonna have the rest of our discussion?
Yes. We can do it all together if you like. Sure.
I've got all this sophisticated equipment. Can you hear me? I'm Bob Pitts with the Associated Builders and Contractors on staff. With me is Kent Starwalt with the Tennessee Road Builders Association. We were here for another reason, which hopefully we'll get to in a moment. But I guess we want to make a couple of observations to you about the draft that's before you in regulation for rules. While we're not here in official capacity for the Go Bill Board, as you know, we're 2 of the 4 sponsoring organizations out of which the board membership of Go Bill comes. Our board, or excuse me, the Go Bill Board has always viewed this legislation is basically for promotional activities to encourage people to careers in the construction industry. Candidly, we did not see a copy of this draft until late yesterday afternoon, and there are some concerns that we are not convinced that the statute as written actually provides for grants to educational institutions. I think you would find the position of the Go Bill Board is that was not the intent of the legislation, that the intent of the legislation was principally and largely solely for the promotion of careers. And for that reason, we'd like to express a concern that we think this grant portion of the rules should be re-looked at, talked about, before any final judgment is made with respect to that piece of the issue.
I'm a little behind, but who wrote or
Our legal
where did
section.
that come from?
Michael Driver, and Josh is just going to get Michael to see if he can answer those questions about the grant, because
I'm in agreement. I don't remember any discussion about grants to educational institutions, and never once in my mind did it occur that that was the intent of what we were going to do.
And our association in Memphis is kind of upset with this. Example being that our association can put on a seminar for people. And we can do it at night, which means we can have an apprentice program during the day where the people can go at night and then work during the day and get paid. The way this bill is written right now, going back to what you just said, it appears that you're going to have to go to school and you're not going to be able to work at that time if you're going to school during the day, and you're not going to be able to get paid. That's what I was told yesterday from our association. And
Well, I think there is a catch provision that allows you to do what you want to do. And that's all in connection with item C on page 2, and what it really says is it can,
You're looking at the statute, right?
I'm sorry, I'm looking at the statute.
where are we going to find this?
On the second page of the little handout she gave you.
Under 449-105, section C.
Okay.
Basically, it says that funds collected can be used, and I'm going to extrapolate and see if you all agree with me, that funds are to be used to encourage and promote career opportunities in the construction industry through career and technical education programs and other certified and nationally accredited programs. So, Ronnie, in answer to your question, at least for a start, if the program that you all are running is through the National Home Builders and is an accredited national program, you would still be okay, in my opinion, day, night, weekends, whenever. It might be helpful while you're waiting on the attorney to come if Kent and I could comment. Some of you may wonder why we're here. We sort of wonder that ourselves. Yesterday, we received an email from Bill Young, who is the retired director of AGC. Bill said that he was supposed to come and give you all an update on Go Bill, but he is in Italy. and asked us if we would come and make a report. So that's what got us here to begin with. In the defense of this being a promotional program, I think there are a couple of things I want to be sure we're all on the same page. About 25 years ago, 30 national construction entities went together and created a standardized curriculum for the construction industry and created the National Center for Construction Education. It's a foundation, and funded it to not only create the standardized curriculum, but to keep it updated. That program was approved by the Tennessee Department of Education to be offered in the high schools of this state. It's been so for years. It also can be used in vocational schools, community colleges, or an individual contractor can use this curriculum. If you're in this accredited approach and schools adopt the standardized curriculum, this is a curriculum that meets the needs of the construction industry. It's portable in the sense that there's a national register where students who graduate or take credit in these programs is put into a national computer and is portable from high schools to other high schools to vocational schools. In other words, the curriculum and the training follows that individual wherever they go, anywhere in the country. So we thought we had sort of solved the problem of curriculum. And then our governor, with a vision, offered free scholarships to anyone who made a passing grade in high school to go to post-secondary training free of charge. So we sort of felt like that we had a curriculum mechanism and a financing mechanism. What the crisis is we don't have enough people coming into the industry. And that's what drove this whole effort to try to create a promotional program to go sell careers in construction as the great place to be. So that sort of all blends into this discussion on the issue we're talking about at the moment. And by the way, some of our organizations do have agreements with high schools in the state where they've adopted the curriculum, and while they cannot get through a full course of training, they can get through part of the training that gets you to journeyman level craft trades, and that's obtainable in the high schools. And our organization, as an example, has agreements with somewhere roughly 50 high schools or school systems in the state to assist them in support of a program that they've instituted in those schools. And some of the other organizations do similar things. Hopefully that'll be helpful to you all in evaluating this. It's not an issue of fighting, it's an issue of what was the intent of the legislation and what is the true need. And the true need is promotion of bringing people into the industry. And frankly, that's a very expensive venture, and there simply is not money to do a major promotional effort, and then in addition to that, offer grants to individual institutions.
A lot of us thought that we were gonna have some promotion on TV or something like that to bring forward, and we don't know where that stands.
I speak, or Kent can speak to that a little bit. You all have been very supportive, of which the industry is deeply appreciative. things have gone a little slower than anticipated, and I guess our job is to give you an update. The Go Bill Board was formed. It is composed of 3 representatives from each of the 4 major construction associations in the state, and every member of that board is out of the industry, and none of the positions are assumed by staff. They've done all their paperwork to be ready to do business. In all honesty, this bill passed so late in the session, and by the time the money flowed to have any money to spend, got us into the fall of last year. The board, I think, made, or in this case, the Go Bill Board, made, in my opinion, a wise decision. They did not want to rush out and spend money foolishly. Realizing where they were in the school year, it is their intent to start spending some money in sort of the last 3 months of this high school year in educating instructors, the school systems, of how all this is going to work in preparation for the big campaign starting with students this coming fall. And I think they made a wise decision not to throw around a bunch of money here mid-year, which could largely be wasted, but to get organized to deal with it next year. Starting probably with some expenditures in March of 16 and selling the system that'll be in place for the coming fall. With respect to any contracts, I think all of you know the original intent was to try to do business with a national entity called Go Bill. It made a lot of sense because the 2 other states that have engaged in this kind of activity have both contracted with them, that is Alabama and Georgia. And for us to do differently now, our board believes would not be a wise judgment because a ton of money has been invested in creating training materials, promotional films, advertising campaign, and a data system to track and keep up with interest of students and family members and to make referrals to possible training sources if they're interested in going to school. That contract was supposed to be available to the board in latter part of January, and they still do not have it. Our board is awaiting the final contract proposal from Go Bill, and we'll call an emergency meeting to review it and hopefully sign it sometime here in the next week or 2. So the ball is not in our court at the moment. It's Go Bill finishing up with their draft of the contract provisions. But you really need to understand that this entity has done a mind-boggling amount of work. Our board has had numerous meetings with them outlining the tasks that they want them to accomplish in Tennessee. And while they will be the lead entity, it is in intent to manage these funds and expenditures of printing of materials or advertising campaign, etc., to try to utilize Tennessee vendors to push that program out. Not that Go Bill would do it all itself, but its strength is in the materials that they've already developed, and we don't have to recreate that. And then I need to conclude on that by saying this national data system is a very comprehensive, complex data system that is being used in these other states. From the time anybody makes an inquiry of a possible interest, that is fed into the system. It is tracked. It is used to do follow-up provision of information to that child, parents, affected institution, and to make them aware of where they can go to register to be involved in a program. Hopefully that'll sort of give you some idea of the approach that is being used with respect to this. We're sorry about the timing part, but the belief of the board was it made more sense to move slowly and not waste money and be sure that they were ready to go largely in the next school year.
Other questions? On your board of directors, this was I understood that somebody from this board would be on the board of directors. That's not so. And the second thing is Governor, Speaker of the Senate, and Speaker of the House, if this board hears with because it's our money from this board that's being given to make this work. And I don't see any mention that we're going to get to see. I was hoping, and this is just me, that Reese would be appointed on the board. And I say that because Reese kind of talked to get things going. I don't mean to throw anything on you, but
He hasn't gone to meddling.
okay, I'm going to meddling. Okay.
No, carry on.
But anyway, that's what I had thought personally. But those are two questions that I have, and I'd just like to be responded to.
I'll take a stab at it.
Okay.
Under the way that the statute is written, vision is that the board is reflective of recommendation